Good morning, students. In this module, we are going to see contract and essentials of valid contract. Let's see what is contract. The legal provision governing contracts are contained in Indian Contract Act 1872. Let's see what is contract. Contract is defined as an agreement enforceable by law. A contract must fulfill two basic conditions. There must be an agreement and it must be enforceable in the court of law. Before entering into the essentials of valid contract, let's see some of the terms relating to contract. First, agreement. What is agreement? Agreement is nothing but every promise and every set of promises forming the consideration for each other. Let's come up with an example. For example, X offers to sell his bicycle to Y for 700. This offer has been accepted by Y. So here, Y's promise to pay 700 forms the consideration for X promise to sell the bicycle and vice versa. So here what they are saying is that here X offers to sell his bicycle for 700. The offer has been accepted by Y. So Y's promise is here to pay 700 and X promise is here is to give this bicycle, but for consideration for both parties there is some consideration. So this is called as an agreement. Next we can see what is promise. A proposal when accepted becomes a promise. For example, A offers to sell his bicycle to B for 25,000. So if A's proposal has been accepted by Y by B, then it becomes a promise. So simple terms we can say agreement is equal to offer plus acceptance. Next we will come with the obligation. So obligation, a contract gives some rise to certain obligations that the parties are expected to fulfill. Here I will come with an example. X a person agrees to sell his car for 1,50,000. The agreement here gives rise to the obligation for X to sell his car for 1,50,000 to the person Y. So here Y has to pay what? 1,50,000. So for both parties there is some obligation. So the obligation can be of two types. One is social obligation and the legal obligation. First let's say what is social obligation. The social obligation is nothing but both the parties are not legally binding. So legally binding in the sense that it is coming out of love or affection. For example, here a father promises to pay his son ₹20 a daily pocket money for his son. Later on, father refuses to give. So a son can sue case on his father, but this case was not being enforceable in the court of law, as it is a domestic agreement and it will not be enforceable in the court of law. That is called as a social obligation. And then comes the legal obligation. Legal obligation is nothing but the intention of the parties is to make legally binding on them, and this agreement will be enforceable in the court of law. Here one example. So X lets his house to Y upon a monthly rent of 20,000. If Y fails to pay X, then X can sue Y. So this is enforceable in the court of law because it has created a legal obligation. So let's sum up with this. Now we have seen what is contract, agreement, obligation, promise, etc. So let's sum up that. What is contract? A contract is equal to, we can say that's agreement plus enforceability by law, whereas agreement is equal to offer plus acceptance. All agreements can have both legal and social obligations, but contract can be only of legal obligation. All agreements are not contracts, but all contracts will have some agreement. This is some terms related to the contract. Next we will move on to the essentials of valid contract. Essentials of valid contract. So there are some of the essentials of valid contract. If these fulfill, then only the contract is valid. First point is that a valid offer and acceptance. So first what they are saying is there must be an offer and there must be acceptance. It should be valid in children. So first, the terms of the offer must be precise and clear. For example, here X a person is giving his bicycle to Y. Here what is the offer given by X? To sell his bicycle. So this is an offer. So the offer must be precise and it should be clear. And second point what they're saying is the offer must be communicated to the person whom it is made. For example, the same example, X is selling his bicycle to Y for 20,000. So here the Y is a person to be communicated. The Y must know that the cycle is going to be, that the X is going to give the cycle to Y. So the offer must be communicated to the person to whom it is made. Third point, the acceptance of the offer must be absolute and unconditional. Absolute it should be, and it should not be in a condition based one. It should be unconditional. The acceptance should be unconditional one. Next is that intention to create legal relationship. As we studied earlier, what is a legal obligation, like here also, the intention of the parties to a contract must create a legal obligation and not the social obligation. Here a case study is that Balfour versus Balfour. Let's see this case study. Here a husband promises his wife to give some monthly expenses amount, but later on what the husband refuses to pay the wife. So wife, what he did, she took legal action against his husband, but court said that it is not legally binding and it is not a legal obligation. It comes under social obligation, so it is not enforceable by the court of law. So what here, the second point in valid contracts, that the intention to create a legal relationship between the parties. Third point is that lawful consideration. Lawful consideration means something in return. So both parties should have benefit arising from the contract. It should not be in the free of cost. So both the parties in the agreement must give and get something in return. Here a simple example, B agrees to sell his bike to Q for 25,000. So Q's promise to pay consideration for P's promise to sell the bike, and P's promise to sell is the consideration to Q's promise to pay. So both parties, the first party, that is P, is going to give his bicycle, his bike, and Q is going to give amount for 25,000. It forms the consideration. So some of the rules what we have to follow in the consideration is, first it must be real and lawful. Real, it should be a real, and it should be a lawful one. It should not be an unlawful one. Second, it must not be necessary in the form of cash or in kind. It can be another one way where to do something or not to do something, or promise to do something or not to do something. This can also be a lawful consideration. Next comes the capacity of the parties. So parties who is entering the contract must be competent to a contract. A person is capable of entering into a valid contract if he has been attained the age of majority, a person of a sound mind, and a person who should not be disqualified from contracting by law. These persons, then they can enter into a contract. Here a simple example, A lends 20,000, 2,000 to be a minor. So if A cannot take legal action B because B is a minor. If B didn't repay the amount to A, then A cannot file a case on B because B is a minor one. So the capacity of parties is that a minor should not enter into a contract, an unsound person or lunatic person, and also who is not capable or disqualified under the contract cannot enter into the contract. Next one is free consent. Free consent. A consent means that is willingness. So in a contract, it should not be a forceful one. The consent of the parties must come freely. It must not be obtained by threatening or suppressing facts. Here an example, X deliberately sells certain indigenously made dress materials as imported ones to Y. So Y is getting the goods by X deliberately by giving a not imported goods. It is some sort of unquality goods. So but here Y doesn't mean that the truth, he doesn't know the truth. So the consent of Y is obtained by fraud. So here it does not come under the free consent. So free consent here in the end, the parties entering into contract must come with willingness. It should not be in a coercion. Coercion means threatening or undue influence or misrepresentation or by fraud. If these happens, then the contract is not a valid contract. Next comes the legality of object. So any contract where we are entering, it should be legal, it should not be immoral, and it should not be opposed to public policy. For example, we can say that a person enter into a contract with B to supply certain prohibited goods. So such an agreement is void as it is subject to illegal one. So giving bribe all comes under illegal one, immoral, or it is opposed to a public policy. So these will not be coming under the valid contract. Next one, terms of the agreement must be certain. So while entering into the contract, both the parties, that is both offerer and the offeree, or the promisor or the promisee, must have, the terms must be very clear, precise and certain. The terms should not be very vague, and if it is vague, then the contract, that is the agreement, cannot be enforced. Here an example: a seller is selling goods, selling milk products to S, a trader, by which R is a person who is supplying the milk products. He said, sir, daily I'll give 200 daily worth milk products to you. But in this contract, they didn't say what type of milk product they are going to give. For example, it may be of a ghee, it may be of a curd, or it may be of a butter. But here the contract is not certain. It's not certain. It is uncertain. So here the contract is not valid. So every time when you enter into the contract, the terms of the agreement must be certain. And possibility, next one comes the possibility of performance. So an agreement, while we are entering, it should be made possible to perform. So if it is not possible to perform, then the contract is not valid. For example, if a person saying that I will turn the iron into gold, if H pays 1 lakh, whether this can be a possible one, it is an impossible one. So this will not be enforced in the court of law. If H pays 1 lakh, and if the G doesn't turn the goods into iron into gold, then and he cannot go and put a case in here, it is not enforceable in the court of law. So a contract entered must be made possible to be performed. And the last one is legal formalities. So while entering into a contract, if it is want to be enforceable in the court of law, it must comply some of the legal formalities, such as that the parties should be coming with an express contract, that is in writing. It should have a stamp duty, it must be have registered, and it should have a certification and witnesses. All these complies the legal formalities. If these satisfied, then the contract is valid. What are the points? First point is that it should be a proper offer and a valid offer and acceptance. Second is the intention to create a legal relationship. Third, a lawful consideration. Fourth is capacity of parties, free consent, legality of object, terms of the agreement must be certain, possibility of performance, and legal formalities. Thank you.